Hello and welcome to HR Options webinar series. My name is Nunzio Presta and I'm a Sales and Marketing Executive with HR Options Canada. It is my pleasure to be your moderator for today's session where we are fortunate to have an all-star lineup of speakers with us to review the complicated topics of cross-border HR, employment, and immigration issues. I will introduce you to all the speakers in a moment, but first I have some housekeeping information to go over. First, you're welcome to submit questions throughout the session by typing them into the Q&A box on your screen. We'll respond to questions at the end of the session. Second, if you'd like to contact any of the speakers to discuss any HR support, outsource employment, or legal needs your organization has, please use the contact widget at the bottom of the screen. Third, all widgets can be minimized and expanded throughout the webcast. And lastly, there is an evaluation widget at the bottom of your screen. We would appreciate it greatly if you could take 3 minutes to respond to those questions. If you have to leave early, not a problem. You can complete it at any time. We use your feedback to help us develop our future webinars. So why does HR Options offer webinar series? Well, it's because we truly believe in value-added services and we pick topics that are of interest to our contacts. HR Options offers outsourced HR support for small and mid-sized companies who need part-time or project HR support. We also offer outsource employment services throughout the U.S. and Canada, so our clients can refer us the workers they know they want to use, but don't want to hire them directly. So it's your workers on our payroll. And now for the main event. It's my pleasure to introduce you to our speakers. First is Catherine Benson. She is a senior human resource consultant with HR Options. Her areas of expertise include reduction and avoidance of workplace liability related to federal and provincial employment law. Next is Stacey Glass. She is also a senior human resource consultant with HR Options. Stacey has a wide range of human resources experience advising on appropriate HR practices to reduce the risk associated with provincial and federal employment law. Next is Marty Rabinovich. He heads the employment law group at Devery Smith & Frank. Marty's practice focuses on representing employers with respect to issues which arise in the workplace. Next is Sabina Mexis. She is a partner in Devery Smith Frank Tax Group, specializing in tax and estate planning for individuals and business owners. Sabina has expertise in cross-border tax, trust, and estate planning. Next is Asher Frankel. He is an experienced Toronto business immigration lawyer with Devery Smith Frank. He joined the business immigration law team in early 2014, bringing over 25 years of experience in immigration law for both Canada and the U.S. And lastly is Aline Sakarian. She is a Toronto-based lawyer at Devery Smith Frank who earned her undergraduate degree from York University and her law degree from the University of Windsor. She was called to the Ontario Bar in 2009. Her practice is focused on providing individual, timely, and professional service on various legal topics. Welcome, everyone. I'm extremely looking forward to listening to all your insight. Now I'll pass it on to Catherine, who will begin today's webcast.
Thank you, Nunzio. So we're going to start the webcast today by walking you through a few considerations from an HR perspective when you're thinking of sending an employee to work in Canada. After that, we'll pass you over to DSF to review these topics in much more depth, and they'll be looking at both a U.S. and Canadian perspectives for cross-border issues. So to start our section, first, U.S. or most international employees can come to Canada as a business visitor without a work permit. A business visitor is someone that comes to Canada without entering the labor market. So for example, someone who comes to Canada for meetings, a site visit, training in product use, or a sales training. Business visitors must prove that their main source of income and their main place of business are outside of Canada. An important consideration in these cases when you're bringing a business visitor into Canada is to ensure that they have proper travel and medical insurance for their time in Canada. The real issues around compliance come into play when your employees are in Canada for more than a business visit. If they're actually going to enter the labor market, meaning that they're working in Canada. As soon as your U.S. employee enters the Canadian labor market, they come under the radar of the Canada Revenue Agency, health and safety regulators, and also become covered by the provincial employment standards and human rights laws. If an international employee enters the Canadian labour market, the CRA, which is again the Canada Revenue Agency, which is equivalent to the IRS in the U.S. for our U.S. listeners, the CRA will be looking at the employee's status and their earnings while in Canada. As soon as you have an employee entering the labour market here, you have to register with the CRA. For example, let's say you had an employee working for you in Canada on a six-month project. As soon as that employee starts earning income while in Canada, that income has to be reported to the CRA. The employee would have to be taxed accordingly for the Canada Pension Plan, known as the CPP, and employment insurance, known as EI, as well as for income tax. So, of course, I'm not a tax expert. I'm in HR. So my intention here is really to give you a general idea of the issues you should consider investigating when sending an employee to work in Canada. And DSF will provide more information on this topic as we go through today's webcast. If the employee is in Canada longer than approximately 6 months and treats Canada as their residence, and are considered a residence by Canada, which again DSF will explore further as we go through the webcast, they are taxed by Canada on their worldwide earnings for the year. If they can show they're a non-resident, they will only be taxed by Canada on income earned in Canada. And again, you'll have to remit the taxes to the Canada Revenue Agency. As an aside, citizens of the U.S. have to file taxes in the U.S. regardless of where they're working. So your U.S. citizen in Canada will have to file 2 returns, one U.S. and one Canadian. If you know your employee is only temporarily in Canada, there are arrangements through the Canada-U.S. tax treaties in which you can obtain a waiver from the IRS to present to the CRA to show that the employee is being taxed and paid out of the U.S. If you have any questions regarding Canadian returns or anything like that, of course, you can refer to DSF's tax department. And now I'm going to pass it over to Stacey to finish HR Options kind of introductory part of the webinar before we turn it over to DSF.
Great, thanks, Catherine. If you send an employee to Canada and they enter the labour market, you will have to register with the Provincial Workers' Compensation Board, depending on which province the work is to be performed in. This means opening an account with the Provincial Workers' Compensation Board and registering your U.S. employees and also paying the premiums as required. Your U.S. Workers' Compensation Insurance carrier may be able to offer an extension to your U.S. employees that provides workers' compensation coverage for their work in Canada, depending on the province. If that's the case, then you will still have to register with the Workers' Compensation Board in that province, but on the reconciliation form, check off that you are exempt from premiums because you have U.S. coverage and provide the extension coverage letter. Like any legislation, there are workers' compensation exemptions. For example, if the employee's position or industry falls in a category not covered by workers' compensation in that province. In Ontario, workers' compensation is handled by the Workplace Safety and Insurance Board, the WSIB. The Ontario non-resident policy states that employees in Canada for a period greater than 10 days performing work that is listed in the Employer Classification Manual means that the company must be registered with the WSIB for coverage for that employee. Workers' compensation in British Columbia is very similar to that. However, in provinces like Alberta and Quebec, employees are only covered if they are residents of the province. If you send your U.S. worker to Alberta or Quebec, you cannot get workers' compensation through the province. And should an accident happen, you are fully responsible for that worker through your insurance. So in this case, ensure your U.S. insurance carrier will cover the employee for out of country. On the webinar platform, we've provided some handouts with links to Provincial Workers' Compensation Board for your reference. Beyond taxes and workers' compensation, you also have to consider the compliance obligations with employment standards and human rights. An employee entering the labour market in Canada will fall under the Employment Standards Act in the province in which they are performing work. There are a few employment standards that you should be probably taking extra note of, even if your employees are only here on a short work project. Something like hours of work, for instance, will apply per province your employee is working in. We've had a lot of clients say that they want their employees working 60-hour weeks, but to do this in Ontario, for instance, it requires a written agreement and consent from the Director of Employment Standards. If you are requiring employees to work over the daily or weekly maximum hours of work, you have to pay them overtime for those hours, generally 1.5 times their hourly rate. You also have to account for public holidays, vacation pay, which is generally about 4% on gross earnings, and termination notice payments, which Marty from DFS will go into and expand on at the end of today's webinar. Of course, like with all legislation, you have to check for exemptions. Again, we've included some handouts on this platform about provincial employment standards for your reference as well. Great. So as we've seen, there are many things to consider when bringing an international employee to work in Canada. This slide highlights some useful options when the need arises to have workers in Canada. One option is to hire a Canadian to do the job where possible, and a third-party employer or outsourced employer, such as HR Options, can be the employer of record for you if you're not set up to employ in Canada. And this means the worker performs work for your company, and HR Options handles the payroll, tax remittances, and human resources administration in Canada. By using the employer of record to outsource your Canadian employment requirements, it does alleviate the pain points of having to navigate the Canadian employment system. Another option for cross-border employees to come and work in Canada is to go through the whole work permit process. Again, a third-party employer can help work with you on that in bringing the employee to Canada, and we always work with partnership with your company and the immigration law firm to ensure that it's a smooth employment to Canada. And hopefully this gives you some options. And now I'd love to turn things over to our DSF partner, Aline, to discuss the details of bringing your U.S. and international workers to Canada. Aline?
Okay. Thanks, Stacey. So I'll be discussing vehicles for doing business in Canada. So just preliminary consideration. So there's some preliminary considerations that U.S. operations or foreign operations need to consider before coming to Canada. And just generally, these include tax planning considerations, control, liability allocation between the foreign entity and the Canadian entity, as well as ownership considerations. A threshold issue would be whether to operate as the Canadian operation as a branch or a sub. With a branch operation, the foreign entity carries on business directly in Canada through that branch operation and would be subject to the same sort of federal and provincial registration requirements that would apply to a corporation, which I will discuss later. Whereas with a sub, the Canadian business operates independent of the foreign entity. With a branch operation, so this is attractive where the Canadian operation is expected to incur significant losses just from a tax planning purpose. The foreign parent is exposed directly to the liabilities of the Canadian operation. So contrast that with a sub operation where liability is limited to the foreign parent entity's capital investment in the Canadian sub. So it's independent in terms of liability. And the sub operation is the preferred method of carrying on business in Canada, just because it's more convenient from an administrative perspective. So now we'll get into the different vehicles. So the corporation, of course, is the most common form of legal entity for business in Canada. Corporations are a legal entity that is separate from its shareholders. With limited exceptions, shareholders are not responsible for debts, liabilities, or obligations of the corporation. And another positive of operating through a corporation is that the corporations enjoy perpetual succession, meaning that it continues to exist even with the death of any or all of its shareholders. Things to consider with incorporation. So first, you should decide whether you want to incorporate federally or provincially. Different legislation exists. With federal corporations, they're governed by the Canada Business Corporations Act, and each province has similar legislation. In Ontario, we have the Ontario Business Corporations Act. All provinces regulate corporate activities in their jurisdiction, so you have different registration requirements, filing requirements, payments of fees. An additional point to consider is that federally or provincially incorporated businesses need to register in each province that they operate in and have to obtain what's called an extra-provincial license. The only exception to this is a provincially incorporated corporation that's carrying on business in its home province. Another consideration if you're looking to carry on business in Quebec, or rather to incorporate in Quebec, the corporation must either have a bilingual name or a French version of its name, unless, of course, the name is a registered trademark. As far as residency requirements go, federally incorporated corporations do have Canadian residency requirements of 25% at the board level. Similarly, where business is to be transacted at a board meeting, again, 25% Canadian resident approval is required. If residency is anticipated to be an issue, consider incorporating in British Columbia, New Brunswick, Quebec, Yukon, or Nova Scotia because they do not have residency requirements for directors. Liability, so with corporations generally, shareholder liability is limited. However, most Canadian jurisdictions allow for unanimous shareholders agreements, which have the effect of transferring certain powers of the directors to the shareholders. And to the extent that these powers are transferred to the shareholders, directors are generally relieved from liability, and the shareholders are then subject to those duties and liabilities. Public versus private or closely held corporations. Public corporations distribute securities to the public and are subject to strict requirements regarding disclosure as well as income tax rules. Private corporations have limited number of shareholders that can restrict transferability of their securities, which would be contained in the Articles of Incorporation or the Articles of Amendment. So I'll just touch on other business vehicles. First, we've got proprietorships. With proprietorships, there's no distinction between the proprietorship and the owner. The owner is the proprietor. The proprietorship's income and liability is the owner's income and liability, and the proprietorship is not a separate taxpayer as with a corporation. Partnerships, so generally a partnership exists when two or more individuals or entities carry on business together with a view to making profit without incorporating the new entity. And there are different types, which I'm not really going to go into detail here. So I've listed limited partnerships or limited liability partnerships. There's also joint ventures, which really are creatures of contracts. This refers to any means where two or more economic entities share in a common venture. Profits or losses are not calculated at the joint venture level. Instead, each co-venture contributes assets or cash to cover expenses and shares in the revenue generated from those assets in the agreed proportion. So really something important to keep in mind is that you need to draft these agreements very carefully so that it's not considered to be a partnership. And that's it for me. I'll turn it over to Sabina Mexis, who is a partner in our tax law group, and she'll be talking about tax issues for cross-border workers.
Hi, Eileen. Thanks very much, everyone. So I'm going to speak about, by way of overview, three different areas that we need to be mindful of in dealing with cross-border workers. And in particular, they are, what are the differences between an employee and an independent contractor? What are the income tax obligations of the employer and the employee in each category? And is, in fact, the worker a resident or a non-resident of Canada? And what are the tax implications of each of those categories? So to start, An employer or an independent contractor, as a matter of law, really does require an analysis of the facts surrounding the relationship between the worker and the company. It really does come down to a question of fact as to how the employee and the employer or the worker are in fact conducting their operations and their relationship to each other. And generally the courts have looked at, and the CRA does consider the following criteria in determining whether a worker is an employee or whether an independent contractor. And those 4 criteria are control, chance of profit or risk of loss, integration, tools and equipment, and I'll be going into a little bit more detail of those in the next slide. So the factors to consider, you can see I've just at a very high level indicated some of the factors that are being considered by the CRA in making a determination of whether someone is an employee or an independent contractor. And generally speaking, in reviewing these factors, you can see that the overriding principle is that the more control that an employer has over the worker, the more likely it is that the worker is going to be considered an employee. The fact that there might be a contract that says the person is being treated as an independent contractor, that in and of itself will not save a relationship from being considered an independent contractor relationship if there is in fact a risk of profit or loss or ownership or control being utilized, being retained by the worker as opposed to by the independent contractor. As opposed to the employer. So if a person is considered an employee, then the payer is going to be the employer, obviously. And if a person is found to be an employer, then they have CPP, EI, and income tax remittance obligations. And the employer is required to deduct and remit both the employee and the employer portion of CPP and EI. And Marty will be speaking more later about termination provisions, but generally if a person is an employer, then it is as an employee, then it's more difficult for them to be terminated. They're also eligible for the Canada Employment Amount Tax Credit and perhaps are also eligible for employee benefits. Generally, an employee-employer relationship is a contract of service, and we contrast that with an independent contractor relationship where the independent contractor generally is self-employed. They're in a business relationship on their own account to carry out their services either as a sole proprietor or as through a corporation. Generally, the expenses that they incur in the conduct of their business are deductible. They're not eligible for EI benefits, and they are engaged in providing a contract for service rather than of service. So they have control over virtually all aspects of the performance of their contract and are simply responsible for the deliverable, whether it is a product or a service or whatever that output is. That's what the independent contractor is responsible for. So why is it important whether one is an employee or one is an independent contractor? It has repercussions on both the employee and the employer, the payer and the payee side. So if someone is considered an employee versus an independent contractor can have impact on all of the different statutes that you see here. So all of these potentially are impacted based on the status of the person. And if the CRA does in fact conduct an audit and determine that a person is in fact an employee, then the company may be subject to significant taxes, penalties, and interest, which I will be discussing in a little bit more detail. So, for example, if you have an employer who fails to withhold and remit income taxes as required, then the employer will be potentially liable to a penalty. And if there is, in fact, criminal ramifications, then there is potentially criminal charges that can be brought under the criminal provisions of the Income Tax Act. And the penalties and interest that are payable are not deductible to the company. So there's a bit of a double whammy as far as the income tax implications of having to make that payment and not being able to deduct the payment. And then in Ontario, we have something called employer health tax. So if the company has not been deducting employer health tax and remitting it, then they would also potentially be liable for that. And then there is also potentially board liability. So the directors can jointly and severally be liable for the income tax which has not been remitted, as well as the CPP contributions which the company was required to remit, as well as EI premiums. So significant potential penalties and interest can be imposed upon the corporation. Now, I'm going to slip by this slide quickly, just because we've already covered it, but generally, again, the implications and the requirements are that the employer will be responsible for CPP, EI, and income tax if they are in fact found to be an employer and not a payer. If it is a true independent contractor relationship, then this responsibility rests with the independent contractor and not with the employer. So now residency. This is a question I get all the time because often when people are crossing the border to come into Canada to work, they don't think that they're potentially subject to Canadian tax because they're not in fact resident. But there are in fact 3 categories of residence, which I will go over quickly here. So the first is factual residency, and you can see that there's a long list of factors on this slide that are considered by the CRA in determining whether someone is resident, not relevant. So that's factual residency. The next is deemed residency. So that's a person who, and it seems like silly, but if you're determined not to be a factual resident, then you could still be considered to be a deemed resident. So that point is actually, in the first bullet point, is put there on purpose because if you're not found to be a factual resident, and you have to not be found to be one in order to be considered to be a deemed resident. So it is important to make that determination. Now, a sojourner is a person who probably many of you will find some of your workers will fall into potentially. So a sojourner is a person who will cross the border and can be temporarily resident in Canada for a total of 183 days or more. So this is important because a part of a day is considered a day for the purpose of counting the days to determine whether someone is a sojourner. If someone is a sojourner, they are in fact then considered a deemed resident for tax purposes. And then finally, a non-resident is a person who is not a sojourner or a resident, a factual resident. And I've indicated in this slide some of the ways where if residency cannot be determined, then there are tiebreaker rules in the treaty that can be utilized in order to make that determination of in which country the person is resident. So if you are a factual resident, then you are subject to Canadian income tax on your worldwide income. Now, if you're a deemed resident, you're still liable for tax on your worldwide income. So, there are tax differences, and I won't go into them here, but just to be mindful that a deemed resident, factual residents are subject to tax on their worldwide income, and non-residents are subject only to tax on their Canadian source income. I will skip by this slide in the interest of time. I will just highlight to you that there are Regulation 102 and 105 that do potentially apply to additional withholdings for non-residents who are providing services in Canada and people who are making payments to non-residents for services in Canada. So we've talked about what the implications are for the employer and the employee. You have to file a tax return. And how do you minimize the risk? I mean, the most important way to minimize the risk is to get proper tax and legal advice prior to sending someone over the border, because the repercussions to both the employer and the employee for non-filing can be potentially significant, with extensive penalties and interest and potential director's liability for unremitted taxes. And with that, I will pass it over to Asher Frankel, who will be speaking on moving skilled workers to Canada. Thank you.
Thank you. Excuse me. Thank you, Sabina. Okay, so let's get to it right away. I mean, obviously, the area of immigration law is very complex, and I don't intend to bombard you in the next 6 to 7 to 8 minutes with a great amount of detail. My purpose is just to draw some comparisons between the U.S. and Canadian immigration systems and to highlight to you some of the advantages of the Canadian immigration system over the U.S. immigration system. Of course, I'm available to answer questions to anybody after the seminar. I think you can find out all of our email addresses, and we'll all be happy to answer questions any of you have in any of our respective areas. So, a lot has been heard about immigration. It was a major topic during the U.S. election campaign. And of course, now President Trump at the time, during his campaign, harped on the fact again and again how immigration had to be tightened. And the reasons were, I've listed these 3 bullet points here. He highlighted purported protection of American security and jobs, and he wanted to address perceived abuses of the immigration system. All of that was the rhetoric before he got into power, and then subsequently when he was elected president, he took advantage of the power to issue several executive orders impacting significantly on immigration law. And I'm sure all of you have heard about the various challenges in the courts to his executive orders. One of the most recent executive orders relating to immigration was titled, and you have it here on the slide, Buy American, Hire American. That executive order was issued on April 18th, and among other factors included in the executive order were very clear instructions to governmental agencies to recommend new and, in fact, tighter immigration rules. And the purpose was to protect the interests of U.S. workers and rigorously enforce the laws governing entry of workers from abroad. These top 2 bullet points are actual quotes from the executive order itself. And in the wake of this executive order, various government agencies involved in immigration law have announced coordinated efforts to reinterpret regulations and focus on enforcement activities. One of the effects that we are seeing of the current U.S. rhetoric is that U.S. companies are establishing subsidiaries or branch offices in Canada, all driven by concerns for foreign workers which are currently employed in these companies and have very uncertain futures in the United States. Now, some of the larger companies such as Microsoft, Google, and Amazon have had operations established in Canada for quite a number of years. In fact, some of the companies have operations in various centers. Microsoft, for example, out on the West Coast in Vancouver, and they also have an operation not too far from Toronto. And likewise, we're seeing now that smaller companies are beginning to establish operations in Canada where they are placing many of their foreign workers. Again, as I mentioned before, due to uncertain futures in the United States. What are some of the Canadian advantages from an immigration perspective? So first of all, relative to the U.S., Canadian work permits are more predictable and are processed faster. Secondly, Canada is party to many free trade agreements with provisions for work permit issuance on a facilitated basis. So, for example, Canada currently has free trade agreements with Chile, Peru, Colombia, South Korea, Mexico, and for the time being, at least, with the United States, although President Trump has already given notice that he intends to renegotiate the NAFTA, which has in it immigration provisions. And there are currently other free trade agreements under negotiation right now, such as something known as the CETA, C-E-T-A, the Canada-Europe Trade Agreement, that's with the European Union, which will also have immigration provisions in it. What are some of the other, excuse me one second. Fighting a bit of a cold here. Some of the other immigration advantages under the Canadian system. So citizens of many countries are travel visa exempt and can apply for a work permit at a port of entry with no time delay. Basically, it's instant adjudication. If you don't need a visa to come to Canada, you can apply for your work permit at the border. Canada has no cap on the number of skilled foreign workers, unlike the United States, which does have caps on certain categories, the H-1B being the most famous or notorious one. Canada has a very generous spousal work permit program, granting spouses open work permits. These are spouses of individuals who are in Canada on other types of work permits. Since we talked about companies establishing operations in Canada, there is the very useful category known as the intra-company transferee, which allows foreign employees to be transferred from a related company outside of Canada to a parent or subsidiary or affiliate in Canada. Now, not all employees qualify. One must be either on a managerial level or an executive, or the worker must possess specialized knowledge, which is a defined term far too complicated to get into here. Intercompany transferees can be processed on a very simplified and expedited process. Canada is now implementing, on June the 12th, you'll be reading in the newspapers, there'll be a new global skills strategy, which is designed to attract high-skilled workers to Canada to fill labor shortages. It will have a simplified application process, and the goal is to process applications in 2 weeks' time. There will be 2 streams, one focusing on high-growth companies, and then there will be another stream where there will be an occupation list, a global talent list, and if the individual's occupation in Canada is on that list, they will receive preferred processing. Other immigration advantages under Canada's system is Canada's permanent resident program is generally predictable and relatively fast, with no per-country quotas as exist in the United States. Canada recently introduced a new express entry system, which is based on points, enabling relatively objective assessment of a candidate's eligibility. And most temporary workers can transition to permanent resident status and eventually Canadian citizenship, which ultimately leads to taking advantage of the various free trade agreements that Canada has with other countries. So in conclusion, while the U.S. appears to be tightening up its immigration policy, Canada is expanding and streamlining its programs. This time, I'd like to hand over the presentation to Marty Rabinovich, who will speak on employment law issues. Marty.
Well, thanks very much, Asher. So my topic today is called Employment Law in Canada, Hirings, Firings, and Everything in Between. Now, given some of the time constraints for today, I'm not sure that I'm going to be able to get to the everything in between, so that may have to be saved for another presentation. But for today, I'd like to talk about the types of contracts that an employer can enter into with an employee, as well as some termination issues, so for termination of employees. Now, again, in the interest of time, there's going to be some of my slides that I'm going to skip right over, but feel free to look at those on your own time. And, of course, if you have any questions about anything in my presentation or any of the information on the slides, I would be happy to answer those questions. So let's just get right into it here. There are two main types of employment contracts that a company can have with an employee. The first is called an indefinite term contract, which, as the name suggests, is a contract with no set final date of employment. Now, if an employee with an indefinite term contract is terminated, that can give rise to a severance package entitlement. The second type of contract that you can have is called a fixed term contract, which would specify a specific start date and end date to the relationship. And certainly employers are welcome to use these. However, I would just caution you that they do need to be drafted properly. There's all sorts of legal issues that can arise that are related to fixed-term contracts. So I would suggest that if you want to use fixed-term contracts, just to speak to a lawyer to make sure that all of these issues are addressed. So I'm just going to jump ahead a few slides actually here. I'm just a few slides ahead. So this one about at-will employment. So many of the American listeners are probably used to having at-will employment, essentially meaning that the employer can one day decide that they don't need an employee anymore and can terminate that employee. In Canada, we don't permit at-will employment. So what we're looking at is if an employee is terminated without cause or without a valid legal reason, then that employee is entitled to a severance package. If the employee is terminated for just cause, meaning that there was a valid legal reason for the termination, then they would not be entitled to a severance package. So just to give a couple of examples here, so when we're talking about just cause, again, so that's the valid legal reason for ending an employment relationship, we'd be looking at conduct such as theft, insubordination, dishonesty, or engaging in bullying and harassment of coworkers. Okay, and then when we're dealing with a termination without cause, so again, that's without a valid legal reason, some examples of a reason why an employer may want to terminate an employee without cause may be something like restructuring, insufficient work, not getting along with coworkers, and so on. So even though those would all be considered good faith reasons for terminating an employee's employment, the employee would nevertheless be entitled to a severance package. Okay, so I'm just going to go to my next slide here. We've skipped a few here. Okay. So I just want to discuss briefly here how to determine a severance package. So again, when you have an employee who has been terminated without cause, they will be entitled to a severance package. And there are three places that we have to look to figure out what that severance package is. So the first place we look is employment standards legislation. So in Ontario, as we saw earlier in the presentation, the statute is called the Employment Standards Act 2000. There are other similar statutes in the different Canadian provinces and territories. So the employee cannot receive less than their minimum entitlements under employment standards legislation. The second place that we have to look is the employment contract, and specifically what we're looking for in the employment contract is an enforceable termination clause. So it could be a clause that simply says that the employee is only entitled to their minimum employment standards entitlements, or it could be a clause which says that the employee, if they're terminated without cause, is entitled to 2 weeks per year of service or 3 weeks per year of service, and so on. Okay? And then the other place that we would have to look is called the common law, which is basically court decisions. And the common law notice period, if we get there, is going to be significantly longer than the minimum standards set out in employment standards legislation. And to be clear, when we're talking about a common law notice period, not only are we talking about, say, 3 months, for example, of notice, but we're also looking at things like benefit continuation, bonuses, shares, stock options, and so on. Okay, so in particular for the American listeners here who are used to having at-will employment in the United States, the best that we can do for you in Canada is to at least limit an employee's entitlement to the minimum entitlements under employment standards legislation if there is a termination without cause. So if that's your intention, I would highly encourage you to speak to a lawyer, because the courts have been getting quite particular about the language that would need to be included in order for those clauses to be enforceable. Okay, so I will just show you here. I'm going to jump ahead again here. Here's an example of a clause that we think is enforceable. Okay, just make a note of that slide. I'm not going to read it out and go through everything here, but again, if you want to have a termination clause in your employment contracts, we highly recommend that you consult with a lawyer about that. Okay, so I just want to get into briefly here a little bit about what we're talking about when it comes to common law reasonable notice. So if there is no termination clause in the employment contract, the sorts of factors that the courts are going to look at in figuring out what the notice period is, it's things like the character of the employment, the length of service, the age of the employee, the availability of similar employment in the workplace. Okay, the courts have established what we call an unofficial cap of 24 months. So very rarely would an employee be entitled to a notice period of more than 24 months. But 24 months, 2 years, that's still a long time, right? So if that's something that your companies wish to avoid, we recommend having strong termination clauses which can protect you from that. Okay, and again, to keep in mind, an employee's common law reasonable notice period is going to be substantially more than their minimum entitlement under employment standards legislation. Okay, so basically what I would say here, okay, and this is the big conclusion, if you're looking to do business in Canada and there's employment issues, we highly recommend that you speak with an employment lawyer to address all employment issues, so related to the hiring, the firing, and the relationship with your employees. And stay tuned, hopefully, for a future presentation on which we can get into more detail about the everything in between. That's the end of my presentation. So, Nunzio, back to you. Thank you.
Well, thank you, Marty, and thanks to all the speakers for trying to condense what could be a day-long conference into about 50 minutes here. But let's jump into some questions that have come in throughout the presentation. So the first one's for Catherine. What is the definition of entering the labor market? Does assisting clients count as entering the labor market?
I'll answer this briefly, and then I'll pass it over to the DSF team. But Yeah, entering the labor market really is doing anything other than just attending like a meeting. If you're actually working with clients or doing work at all, you're entering the labor market. That's my understanding. So maybe if someone from the DSF team can expand on that.
Yeah, I'm happy to jump in. This is Asher Frankel. From an immigration perspective, the term employment is defined in the immigration regulations, and it's basically anything that one would receive remuneration for, whether or not remuneration is actually received. So, for example, if you're coming into and you say, well, I'm not getting paid for it, I'm volunteering, you could be considered to be entering into the Canadian labor market regardless of whether or not you're being paid for it. If you're providing a service or engaged in an activity that one would normally be paid for it in the Canadian labor market, then you could be found to be working in Canada.
Perfect. Thank you, Catherine and Asher. Another open question, I guess, for the DSF team here. What if we have an international employee on a U.S. work permit? Does that help the employee enter Canada to work?
So again, I'll jump in. The answer is no. I mean, every person who seeks to work in Canada has to qualify for a work permit based on the immigration guidelines. And the fact that the person is currently in the United States might make the process a little bit different. In other words, let's say the person is from somewhere in Europe or some other country overseas, rather than the process taking place in that country where the processing time may be longer or shorter, it'll generally go through the United States. So, for example, if the individual needs a visa to come to Canada, it'll be processed through a Canadian consulate in the United States. And again, depending on processing times, it may be quicker or shorter. But the short answer to the question is no. The mere fact that the individual is in the United States in some working status does not give that person any substantive advantage in terms of being permitted to work in Canada.
Thank you. Next question is for Stacy. Are workers' compensation premiums remitted to the CRA?
No, workers' compensation premiums are actually submitted to the board, the workers' compensation board that you have to register in within each province. So it goes to those particular boards and not to the CRA.
Perfect. Thank you, Stacy. We have another question. This is for Aline. What is involved in setting up a corporation in Ontario?
So once the tax considerations and the liability and control matters are addressed, incorporation doesn't really take very long. We'll need to know if we're proceeding with a federal or a provincial incorporation, if the entity wishes to operate under a named corporation or a numbered corporation. So with a named corporation, we usually we have to conduct a name search to see if the name is available in the jurisdiction or jurisdictions in which the entity wishes to operate, and then also get the extra provincial licenses.
Perfect. Thank you. Next question for Sabina. What if the employee carries on business through a corporation?
Thank you, Nunzio. So specifically, if an sometimes employers think that if they hire a person to do the work and that person is working through using their own corporation, that should be sufficient to have that person be considered to be an independent contractor. However, there are provisions in the Income Tax Act that deal with something called a personal services business. So what that means basically is that if a person is basically an incorporated employee, in other words, the control and the other factors that I spoke about in my presentation are really being met, and therefore lead to a conclusion that the person really is in fact operating as an employee, the fact that they're operating through a corporation will deny them some of the positive tax benefits of operating through a corporation, and they will in fact be treated as being working through a personal services business.
Perfect. Thank you. And we have a question here for Marty. How do you recommend handling performance concerns? Should a process be documented in the employment contract? What documentation / due diligence would need to occur before termination due to poor performance would be possible?
Okay, thank you for that question. So in general terms, whenever you're dealing with an employee who has performance-related issues, either because they're not performing well in their role or they're engaging in other sort of misconduct while at work, you as an employer would certainly want to document that. So, I mean, you do need to communicate those concerns to the employee. So you would want to probably start off with verbal warnings and then give written warnings and then consider whether you want to suspend that employee from work either with or without pay, depending on the nature of the misconduct and any other circumstances. Now, in terms of setting out what the performance standards should be, that can either be addressed in the employment contract or perhaps even in the company's policies and procedures and expectations manual.
Perfect. Thank you, Marty. We have another question here for Asher. Are there any work type activities one may engage in without a work permit? Asher, you there?
Yeah, I'm here. I have to unmute my phone. I forgot to do that. Sorry about that.
No problem.
So, yeah, I began to say there are indeed, there is a section under the immigration regulations which lists a whole host of activities that one may engage in as without having a work permit. Perhaps one of the most important ones is the business visitor category, which was mentioned right at the very start of this session. And a subcategory under the business visitor category is the after-sales service. And very briefly, what that means is if there is a seller outside of Canada, let's say a seller of industrial or commercial equipment in the United States, who sells to a Canadian purchaser, then the seller, provided certain conditions are met, there's a contract for sale and the contract calls for after-sales service, then the seller can send individuals to Canada to provide after-sales service such as installation of the equipment, training on how to use the equipment, etc. And those individuals are permitted into the country as visitors without the need for a work permit. Now, of course, it has to be well documented. I wouldn't suggest somebody just shows up at the airport and says, I'm here to provide after-sales service. But assuming it is well documented, that is one very important, very useful example of an activity that does not require a work-type activity that does not require a work permit. There are many others, but again, I don't want to take up too much time now.
Perfect. Thank you, Asher. So we have time for one more question, but I also want to ask all the participants to please take a minute to complete the evaluation that should have popped up on your screen. If it was blocked, you can simply click the evaluation widget at the bottom of the screen. And our last question is to the entire panel, and it may take a little bit more than 2 minutes to get your comments on this, but I'll ask it anyways. So Canadians with Nexus Pass are being subjected to stringent screening at the U.S. border in the Trump era, which is not supposed to be the case. Comments, please.
Well, I can comment very quickly from an immigration perspective. We're seeing not only Nexus card holders, but individuals who have already received work permits, especially those who are applying or have applied previously under the NAFTA. There is something called the TN category. whereby professionals are supposed to be able to gain easy access into the United States. And I think the wording in the question of Trump era is needs to be highlighted. We're seeing, as I mentioned at the very beginning of my presentation, a dramatic reorientation of U.S. immigration policy, and it's trickling down right up to the low-level officers at the airport. And the Nexus difficulty entering with a Nexus pass is just one manifestation of that new phenomenon now.
Thank you, Asher. Appreciate that. So we are out of time for today, and I want to thank the entire panel for their time and for sharing so much valuable information. I also want to thank you all for joining us today, and I look forward to seeing you online at future webinars, and hope you have a great day. Bye, everyone.